Last night I attended a dinner in honor of the retiring Chief Judge from the Maryland Supreme Court, Bob Bell, and he was in a room with as much energy as this room was, and the moderator or the person who was setting up and introducing the panels was trying to get people's attention, and ultimately Judge Bell walked up and started pounding on the microphone, and then when they looked up and saw that he was calling them to order, they got quiet. And so I was hoping I would not have to start beating on the microphone this afternoon. I always apologize at the beginning of this lunch for making you listen to me, because the energy and the opportunity to fellowship with each other is such an important part of this judicial conference. It is where we have an opportunity to step back from what we do every day and actually get to talk about things that are of interest to us beyond the practice of law. And even if it does concern the practice of law, it's usually to improve the administration of justice. And so cutting all those conversations short is something that I don't enjoy doing, but it's necessary, else we'd never get through a luncheon program. For those of you who were not there at this morning's opening or the plenary, my name is Eric Washington. I'm the Chief Judge of the District of Columbia Court of Appeals. And on behalf of the Committee on Arrangements and all my colleagues on the Court of Appeals, I want to welcome all the delegates to this, the 38th Annual Judicial Conference of the District of Columbia. I am going to take just a few minutes and only by way of reintroducing them to you, I wanted to introduce the members of the dais. To my far left, of course, he spoke this morning and gave a wonderful State of the Bar address, President of the D.C. Bar, Tom Williamson. Seated to his right is our keynote speaker, who you will hear much more about a little later on in the program when I have the pleasure of introducing him, Mr. Stephen Bright. Of course, the Chief Judge of the Superior Court of the District of Columbia, Lee Satterfield. To my right, closest to me, Chief Judge Royce Lamberth of the United States District Court for the District of Columbia. Royce, thanks for coming. And of course, the co-chair of the Committee on Arrangements and the judge most responsible for putting this program together, Judge Beckwith. I do want to, although everyone here knows how important they are to me and to the administration of justice here in the District of Columbia, I do want to take just a few minutes, though, to recognize some of those who are in attendance who I think are deserving of special recognition. Everybody's special, but these, I would feel I would be remiss if I didn't acknowledge their presence. And first I'd like to acknowledge the presence of the former Chief Judges of the District of Columbia Court of Appeals who are in attendance, Anise Wagner, and I think Ted Newman is here, and maybe Bill Pryor. I thought I saw the former Chief Judge of the D.C. Superior Court, Rufus King, if he's here.
He's working.
Oh, he's working.
He's working.
That's it. I tell you, this is a good lesson. Senior judges, he's a former chief judge, but he's working one of our statutory courts today, and couldn't be here. But I do want to thank him for that service and also recognize him here. We're also joined today by the former Chief Judge of the United States Court of Appeals for the Armed Forces, Andy Efron. Andy. Yeah. And I would like to, I've introduced Chief Judge Lamberth, but I also would love for the judges who are here for the United States District Court for the District of Columbia to please stand. It's our guest. Two of those judges, Judge Friedman, Judge Walton, penned an op-ed today that directly addresses the impact of the sequester on the provision of access, provision of justice in America, and I commend that article to you. It's in keeping with the theme of this program, and I would thank them for their leadership in that area. I also want to recognize the past presidents of the D.C. Bar who are here. I know there's a number of them. If they'd please stand. And of course, they are ably supported by Catherine Mazzafari and the executive staff of the D.C. Bar. And please, would you please stand, everyone, and the leadership of the bar to receive our applause. We also have with us today an important component of our justice system in the District of Columbia, represented in the person of Chief Judge Mary Oates Walker and the judges from the D.C. Office of Administrative Hearings. Chief Judge Walker. The United States Attorney Ron Machen could not be here with us today, but I understand that his Deputy United States Attorney for the District of Columbia, Vince Cohen, may be here. If he is, I'd ask him to stand. He's not here yet, but I do, and I know she's here, and I'm not even going to look for her because we have this issue. But Avis Buchanan, the Director of the D.C. Public Defender Service, is here. And on behalf of all of your lawyers, thank you for being here. I have not seen the Attorney General, but I am pleased to note that Todd Kim, the Solicitor General for the District of Columbia, is here. And I want to recognize Todd and the staff of the Office of Attorney General. And I have there are a number of voluntary bar presidents who have joined us, and I would be remiss if I didn't ask those voluntary bar presidents who are here to please also stand and let us recognize you. Voluntary bar presidents. We are going to, there are probably individuals and groups that I have missed. Of course, the judges from the Superior Court and the Court of Appeals, I'm so pleased to see you, but of course you're required to be here, so I'm not going to introduce you. I'm much more interested in those who have come as delegates to engage in this conversation with us. And so to all of the delegates who have come to this conference, thank you so much for supporting this joint bench bar conference in the way that you have. I asked this morning my colleague, Judge Corey Beckwith, whether any resolutions had been submitted that would require a special session be held during this conference, and she at that time informed me there were none, but we have now since had some time. Have there been any resolutions submitted? Hearing that there are no resolutions that have been submitted for our consideration as a conference, we will not be scheduling a special plenary session at the end of the day. I will come back in a little while to introduce you to our outstanding luncheon speaker, keynote speaker, but at this time, I'd ask all of you to enjoy each other, enjoy the meal, and we'll see you soon. I certainly wanted everyone to have plenty of opportunity to enjoy their meal and enjoy their company, and I believe we may even have a little bit of time without compromising the ability of the afternoon sessions to get done, or to get started on time, for you to engage in further conversation. Before I introduce our guest speaker, I do want to correct one oversight and one misstatement that I made earlier. First, the correction on oversight. That, and with apologies, I did not, and I should have, introduced to you and had her stand the president-elect of the D.C. Bar, Andrea Furster, who is also here. I asked the past presidents to stand, but I wasn't thinking Andrea. Please forgive me. I misspoke this morning during my conference opening remarks to the extent that I said that you had your annual report information. I know you didn't hear, what you heard was, I'm not going to stand here and give you numbers and talk about performance and bore you to death. But what I also said was you had information in your package. That is old school thinking. But the information is available. It is on our website, dccourts.gov, and under the column that says About, you scroll down to Organizational Performance, and you will get more information than you probably ever want to see about how the D.C. courts are operating. And I just wanted to make clear that if you're looking, and I know many of you rushed to look for that annual report when I said that, you will not find it. It is a distinct honor and pleasure at this time for me to introduce to you our keynote luncheon speaker, and from a lot of those of us in this room, to reintroduce you to our keynote speaker. Stephen Bright has devoted his entire legal career in pursuit of justice for indigent defendants. He currently serves as president and senior counsel of the Southern Center for Human Rights, which provides legal representation to people facing the death penalty, challenges human rights violations in prisons and jails, seeks through litigation and advocacy to improve legal representation for poor people accused of crimes, and advocates for criminal justice system reform on behalf of those affected by the system in the southern United States. Mr. Bright has more than 30 years of personal experience representing people facing the death penalty at trial, appeal, and post-conviction stages of capital cases in state and in federal court. After beginning his career as a legal services attorney with the Appalachian Research and Defense Fund in Lexington, Kentucky, Mr. Bright came to the District of Columbia, first as a trial attorney in the District of Columbia Public Defender Service, and later as executive director of the District of Columbia Law Students in Court program. He also is sharing his unique experience with the next generation of lawyers as a visiting lecturer at Yale and the University of Georgia Law Schools. I think that that's fine, and I think many of us knew about some of Mr. Bright's accomplishments, but I think what's more telling about who he is as a person comes from people who know him best. And and somebody we know well, Professor Ogletree, who is also the chair, I believe, of the board of the Southern Center for Human Rights, has said about our speaker, for a generation, Mr. Bright has called on attorneys to represent the poor and the marginalized in our nation's jails and prisons, particularly those on death row. Steve evokes the very best in us personally, reminding us of the essential obligations and aspirations of the law. It's that exceptional ability to inspire that also led many of our colleagues, before they joined the bench, to join in the efforts to provide high-quality representation to those defendants who were represented by the predecessor organization, but also, I'll just refer to it now, it used to be the Southern Prisoners Defense, Southern Prisoners Defense Committee, now, of course, SCHR. And there was an article that wrote about his activities in that regard and his efforts. And the article talks about him as having a reputation as a tireless legal services, that he was tireless, forceful, and highly skilled advocate for that community, that he sets the example of excellence in advocacy and client relations. And his ability, to me, is no better exemplified than by his ability to recruit his former colleagues from D.C. and elsewhere to come and join him in his fight. Amongst those was Bob Moran, now a D.C. Superior Court judge, who accompanied Steve to Atlanta and stayed for 18 months. In addition to providing excellent representation in numerous capital petitioners, apparently he took over the office books and gradually, allegedly, sorted out the financial difficulties. No, actually did a great job.
He did.
And then he was joined by Russ Cannon, now a D.C. Superior Court judge, and to work on those cases. Despite the extraordinary efforts of those outstanding lawyers, now judges, there were still so many cases to handle that he cajoled other individuals who were associated with our PDS, our D.C. Office of Public Defender Service, to help him out, and other colleagues that he knew from D.C., amongst them my colleague Steve Glickman on the D.C. Court of Appeals now. So I think that the courts are well represented by people who come to their positions and are with many experiences, but certainly this is one that is, I think, life-changing and perhaps makes them to actually better judges. The article that I was referring to also referred to the long hours that Mr. Bright works, and I was pleased to see that lunch usually for Steve is a peanut butter sandwich and an extravagant dinner, a burger from Wendy's. So at least I hope that we've done well by you in terms of providing sustenance for your speech this afternoon, and that you have enjoyed your meal here today, and that but anytime you want peanut butter, we can manage that also. A book called Ordinary Injustice by legal journalist Amy Bach, talking about the Southern Sinner, said the Southern Sinner is fueled by a profound sense of purpose and by Bright's inspiration. It's interesting because his staffer in this article talks about they wondered when he did eat, other than the peanut butter sandwich and the burger from Wendy's, and yet he worked 18, 19, 20 hours a day. And they noticed that at one time when they rolled in the office about 3 a.m., they saw him downing an energy drink at his computer, and that answered all their questions. I think the one title that he may feel most proud of, perhaps, but it's certainly one that I can see you wearing very powerfully in your work, is the title that was given to him in a 2003 Fulton County Daily Report, that's Atlantic Legal News, cover story, when they referred to him as Agitator of the Year. And they named him Newsmaker of the Year for succeeding in pushing Georgia's General Assembly to establish a statewide public defender service. His firebrand style, his passion for the rights of those who have been denied the kind of access to justice that we all see as an ideal, has been uncompromising, and it is with a great deal of pleasure that I introduce him to you, ladies and gentlemen, Mr. Stephen Bright.
Thank you very much, Chief. That was extraordinarily generous. I told Judge Becker this morning, I said, don't get people, don't increase expectations, lure them. But I'm so glad to be home. This is home for me. But the last time I was at a judicial conference, a D.C. Superior Court, Court Superior Conference, about 33 years ago. And one of the people who was invited to speak was the professor, Hofstra Law Professor Monroe Friedman. Professor Friedman, as many of you I'm sure know, is an expert on legal ethics, and he wrote a great deal about legal ethics. And at some point, he had apparently said something controversial in the high volume of scholarship that he had produced up until then and had continued to this day to produce. And so there was a controversy about whether Professor Friedman should speak at this event. And when he did speak, a number of the Superior Court judges got up and walked out, dramatically walked out. I remember some of them faces were so red they looked like little beacons on the top of a police car. They were just... And I remember I was a young lawyer then, I was sitting there looking, I said, I didn't think these guys were that open-minded, but I thought they were supposed to pretend that they were, Friedman then comes on, I can't wait to see what's going to happen now. The judge had walked out, what's going to happen now? He gives his dry academic speech, Well, I'm glad nobody's walked out so far, but we'll see what happens before it's all over. Chief talked about the people who have come here, or judges now, who were at the center at one time, and I want to mention one other. Your newest magistrate judge, Gretchen Rohr, was a lawyer at the Southern Center for Human Rights. And she sort of created a fear that I had when Judge Cannon and Judge Moran got on the bench, is that were people using my office as a stepping stone to the bench? Well, we will see. Of course, also, I can't name all the people, but I just say Steve Glickman started with me at Public Defender. We started at the same time. After he went to his law firm, after that, he took on a death penalty case and argued it, we litigated it all the way through state and post-conviction review, and the death penalty was set aside. Our client got a life sentence. Today he's living in Macon, Georgia. He's no longer even in custody, and that's great work that Steve Glickman did before he became a great judge. And of course, my dear and close friend who worked with me at Law Students in Court, Jerry Fisher, who not only took a capital case, and he won his case and got a double jeopardy bar to ever having his client tried again. With regard to the Agitator of the Year Awards, you know, when that happened, I just happened the next week to see one of my idols and friends, Dr. Joseph Lowry, the head of the Southern Christian Leadership Conference. And he said, well, you know about that agitator thing. He said, when I was a preacher in Mobile, somebody called me a civil rights agitator. And he said, the next week I was visiting with one of my, member of my congregation, and she said, Dr. Lowry, come on, I want to show you something. He took her back to the back part of the house and took her in this room back there, and she opened up her washing machine. And she said, I'm going to tell you something. It doesn't matter how hot the water. It doesn't matter how strong the soap. You've got to have an agitator. So I have taken on that role with some gusto, more than some of my friends would say is appropriate at times. But I also want to say this. Charles Ogletree was with me at the Public Defender Service, my dear friend and colleague, and we still very close. He served for 30 years. He thought he had life tenure, but he finally persuaded us, and he's no longer the chair, but he was just until very recently. I want to recognize our chair, Maureen Del Duca, is here. And as I said to somebody the other day, you haven't seen anything yet in terms of what we're going to do. But the lessons I've learned here have been so valuable to me in the last 30 years in trying to deal with jurisdictions which literally have treated Gideon versus Wainwright as an unfunded mandate. Of course, Gideon came down in 1963. A lot of the southern states at that time all the southern states at that time and some other places were engaged in massive resistance to Brown versus Board of Education. Still are today, some of them. And there was resistance to Gideon in the same way, in that this was a states' rights issue, and that the federal United States Supreme Court couldn't tell Georgia, Alabama, Mississippi, and other states what to do with regard to their criminal justice system. Many of them started out by conscripting lawyers. If you remember the bar in some places, you just had to, every time your turn came, you took a criminal case. You didn't get paid anything for it. A little bit later, contracts where people were paid a flat rate to handle all the indigent cases. That not only happens in places like Georgia, but it happens in lots of other places. California, 24 counties in California contract with law firms or lawyers to handle all of their indigent cases. And they bid each other down to the point that one law firm out there is known as the Walmart of legal representation. One lawyer there said that he handled 70%, resolved 70% of his cases at the first appearance hearing with a guilty plea after a 30-second conversation with his clients. We have this culture, as John Rapping talked about this morning, and as John Rapping is doing so much to change it, this culture of minimal or token representation. I go to courtrooms where I see 40, 50 people come in the courtroom. None of them have ever seen a lawyer yet. They're all accused of crimes. Sometimes I go to courtrooms where it looks like a slave ship is docked outside the courthouse. All these black men are brought in chains and jumpsuits. No dignity whatsoever. And a lawyer goes down the line and talks to them, and then a few minutes later, they all plead guilty and are sentenced. In the first example, where you had free world people, the judge will take the bench and he'll say, now I'm going to give you some time. Now, this is the district attorney. This is the public defender, and I'm going to leave the bench for a little while, and you can talk to either the district attorney or the public defender. Doesn't give them any idea why you might, if you're accused of a crime, want to talk to one as opposed to the other. And so he leaves, and people do line up, both DAs and at the public defender. A lot of people line up at the DAs because they know that they're not going to get anything at the public defender except what I'll tell you in a minute. Judge takes the bench again and then takes guilty pleas from almost all those people. And they'll line up in 5, 10, one courtroom we were in the other day, 17 people were all pleading guilty at the same time. And the judge goes down, everybody answers the questions. You know, you waive right to a lawyer, you appeal, jury, take the stand if you want, not if you don't want that, all those rights. And then the judge sentences one at a time. And the prosecutor's at one end of the line and the so-called public defender's at the other end of the line, and the prosecutor asks for jail time or restitution or fine, whatever it is that they may want. And then the public defender says, Your Honor, I would ask that you impose the $50 public defender fee. That's all he says. Of course, he doesn't know. There's no legal representation going on here. I mean, he doesn't know anything about the clients. He never met them before. He doesn't know anything about the cases. He's never even seen a police report. He can't advocate for sentencing. But if you're the guy standing there, say, wait a minute, who's on my side? This person wants me to be fine. This person wants me to be fine. Who's on my side? And that's why a lot of people go to the district attorney, because the word in the community is you're not going to get $50 worth of representation from the public defender. You can plead guilty after talking to the district attorney, and it won't cost you $50. It's the same plea. I see and have seen over the last 30 years attorneys generals from the states defend cases in which people were sentenced to death and represented by lawyers who were incompetent, who were intoxicated, who were asleep. 3 cases in Houston, Texas, where lawyers slept. One of the judges, people always say, what do the judges do in that situation? And actually, there was not a lawyer, but a reporter from the Houston Chronicle asked Judge Doug Schaefer, a judge in Houston, how can you be presiding over a capital case where the lawyer is sleeping during the trial? He was actually snoring. There's no question about sleeping. And the judge said, well, the Constitution guarantees you a right to a lawyer, but it doesn't guarantee you that the lawyer has to be awake. Now, that, I suppose, is what we call a strict constructionist. Just recently, the latest out of the 11th Circuit, Robert Halsey sentenced to death by a lawyer who was drinking a quart of vodka every day during the trial because he was about to be indicted and disbarred, convicted and disbarred for stealing client funds. It really wasn't focused that much on the case. I learned from being here at the Public Defender Service that if we're going to provide representation to poor people accused of crimes, we have to have structure, we have to have resources, we have to have training, like John Rapping provided here at Public Defender and is providing to people now. We have to have supervision, and we have to have independence. Now, let me talk about that for a minute. I learned the value of independence when I was here as a public defender. I've had a little heart problems over my life, and my cardiologist was a doctor named Michael Haberstam. In 1980, as some of you will remember, Michael was shot in his home by a man named Bernard Welch. Michael was a wonderful doctor and a wonderful friend, and it was a great loss to our community because he died. But I was deeply disturbed by what happened when Bernard Welch was brought to court. He was captured that night. Michael drove himself to the hospital, and he saw Welch as he was driving to the hospital, and he veered off and ran over him with his car. Not hurt him very bad, but they were able to capture him. But the trial judge who was presiding, this was when Superior Court judges did this, Judge Don Smith, who was everything a judge should not be, hateful, mean to litigants, let's say equal opportunity, mean to both U.S. attorneys and the public defenders. But he appointed a lawyer that left no doubt that Bernard Welch would be convicted in that case. And everybody in the courthouse knew what the deal was. Everybody knew what was going on, that he was going to be, of course, we knew he was guilty. I mean, after all, he got run over right after the crime, but it just didn't feel quite right. But nobody did anything about it. And since then, I've seen so many cases where the outcome of the case was determined, just like that case, by the lawyer who was appointed. Lawyers being appointed who didn't have the ability, the inclination, the competence to represent their client competently. Jason Reeves was represented in Louisiana by a group that specialized in death penalty representation. At the guilt phase, the jury hung. So the case comes back for retrial. Well, you'd think this organization, I mean, they specialize in death penalty work. They tried the first case. Why wouldn't they represent him at the retrial? The trial judge said, no, we can't afford that. Can't afford it. We'll have the local public defender. The local public defender said, wait a minute, I have 500 cases. I can't possibly take on this death penalty case. Judge said, well, you will. And he did. And, of course, the outcome is a foregone conclusion. I mean, the trial is just a formality. Jason Reeves was sent to death row. He was convicted and sent to death row. Of course, here in D.C., so much more has been done to comply with Gideon than any other part of the country, as we've talked about this morning. The Public Defender Service is the premier public defender service in the country, public defender program in the country. The civil legal services, as we talked about this morning, is much better than what we have everywhere else, although, or in many other places, although every day I hear from people with the most compelling. People are being forced out of the country, forced out of their homes, deprived of their children, all of these civil issues, no lawyer at all. I contacted we was talking about legal services and domestic violence. I contacted a woman who was telling me about her, this is really a rigged case, I think. She came up from Florida, and a Georgia judge gave her son, who's 15 years old, doing quite well, to the father, who was represented by counsel. She was not. And I called the head of our legal services. I said, can't we do something about this? It's terrible for the child as well as the mother. She said, we're so overextended right now. The only family cases we take are where there's domestic violence, where somebody is in danger. And that's the standard in Georgia today. I know now that you have a CJA panel, which is a little different than it was when I was here. I used to meet some of the CJA lawyers on the elevator, and they had alcohol on their breath at 9 o'clock in the morning. I'll never forget one time when Louis Horowitz, as you may remember, was before Judge Burka, and he put his hand in his pocket like this, and Judge Burka said, "Oh, Mr. Horowitz, I see you're going back to your office." And everybody had a good laugh. But the fact of the matter is Louis probably shouldn't have been representing anybody, and I understand you now have lawyers who have to be admitted to be on the list, and they have to reapply every 4 years, and you have practice standards for those lawyers. That was certainly not what you had 35 years ago. Although I would respectfully submit that you might want to get client input on who you put on that list. I understand you have an advisory committee. I understand you talk to all the judges and what the judges think. As Rapp pointed out this morning, sometimes lawyers may think if they depend upon judges for appointments, this goes back to independence, that they'd better be more loyal to the judge than to their clients. But I also find the value in the film you saw this morning, John not only had lawyers come and talk to these young lawyers that are going out to be public defenders, but he had clients come and talk to them. Just last Monday in my class, I had William Neal Moore, who spent 16 and a half years on death row, come and talk to my class on capital punishment at Yale, because I thought if we're going to talk about capital punishment, we ought to see it from the perspective of someone who had suffered or had the death penalty inflicted upon them, who came within 7 hours of execution, and who dealt with lawyers, extraordinarily frustrating relations with lawyers over that time that he was on death row. Clients may have a different perspective than judges. I know how conscientious the judges here are, but judges often are worried about moving dockets and things being efficient. Clients are worried about people coming to see them at the jail, worried about explaining things, counseling, and all of those kinds of things. You might want to have somebody besides judges decide who gets on the panel. Gideon versus Wainwright was about two things. It was about fairness, that any person hauled into court, charged with a crime, who couldn't afford a lawyer was entitled to one. And secondly, it was about people standing equal before the law. The same day that it decided Gideon versus Wainwright, the court decided Douglas versus California, which held everyone had a right to a lawyer on appeal. And they repeated there what they had said earlier in Griffin versus Illinois: there can be no equal justice when the kind of justice a person gets depends upon the amount of money he or she has. Well, of course, we all know that nothing matters more than the kind of money one has for representation. That's almost everywhere. But with a few exceptions, in D.C. being one where you're probably better represented by the public defender, Colorado being a state where people argue you're better represented by the public defender than by some of the private lawyers there. But one of the other things about Gideon was standing equal before the law and recognizing the dignity of people accused of crimes. And we talked a little bit about that this morning. I'd like to just add a little more to that. At the law school at Yale on Monday, we had a very interesting program about these efforts to try to prevent crime, to try to identify people in gangs or in criminal behavior and bring them in and have them meet with police officers and social service agencies and other people and try to convince them to not have guns and to stop the violence. This was the kind of program that was used in Chicago, basically stopped homicides in Boston for almost 3 years, the so-called Boston Miracle. Now it's being tried by some of my colleagues at Yale and Chicago, where gun violence has been such a tremendous problem and has resulted in so many sad tragedies over the last year. And it seems important to me. It seems that if we could prevent crime, instead of sending people away for a very long time after someone's been killed, we would be improving law enforcement in this country tremendously. And they talked about various aspects of this, and I can't talk about it all, participation in the system and all that, but I want to talk about two things that are relevant to counsel. First, people are less likely to engage in crime if they see the system as legitimate, if they believe it treats them fairly, regardless of the outcome, if it believes they've been treated fairly, and treats them with dignity. A caring, capable lawyer is essential to fairness. It's essential to a person feeling that he or she is being treated fairly. But people will not have that feeling if they're subject to sentencing that is vastly disproportionate to the crime. And not only the lawyer must recognize the dignity of every client, but so must the other people in the system, the police and the court officials. One of my friends at Yale, Jeffrey Fagan, has been studying stop and frisk in New York. You know, if you're black or Latino in New York and in certain parts of town, you're going to be stopped and frisked. That just, think about what it would be like for any of you. Just you walk out onto Pennsylvania Avenue and somebody stops you. You haven't done a thing. Stops you. Slams you down on the ground. Goes through your pockets. Sometimes handcuffs. Sometimes pull out a gun. Sometimes put you in a squad car. And then says, fine. Walk on down the street. This happens all the time. One young man wrote an op-ed in the New York Times about how this had happened to him 5 times. Never college student, never been in any trouble, never arrested for anything, because these 98% of these stops and frisks don't produce any drugs or any guns or any other thing in which you can arrest a person for. One of the things we're beginning to see is that this results in post-traumatic stress. That people who've been treated like that by the police, people who wake up at night remembering the time that they were slammed down, the time that they were told to get in the squad car, the time that they were, my friend Brian Stevenson. I'll never forget the morning Brian came into work and told me how he got home the night before, and he's listening to Sly and the Family Stones, and he wanted to hear the song all the way over, and he got out of the car. And the next thing you know, there are all these cops around him with their guns pointed at him and these spread eagle on the front of the car. And all his neighbors are gathering around now to see. This is a Harvard graduate, a Harvard Law School, a lawyer here at the Southern Center for Human Rights. It was a very traumatic occasion. And, of course, at the end of it all, good night. Not just because he's black. We had something along that line with Chief Justice Satterfield, and I was teaching a few years ago at Georgetown. I sent all my students to Court C-10. And I said, just go to court, watch court, and write up what you see, and what do you think about it? And it was very interesting, the reactions. The students were all horrified by what they saw. And the thing they were most horrified by was the way not only the prisoners were being treated, but the way in which their families were being treated. That you couldn't hear what was going on in the courtroom. That people were out talking among themselves and nobody was explaining what was going on. That the defendants were being, handed around by marshals and so forth in the way that they were. And they all wrote these reaction papers. I finally said to one student, why don't you just put all these together, send them to the chief judge? Well, let's just see. And, of course, the chief had them all over and had them in his conference room and talked about it. And I understand it had a little something to do with the C-10 project, which has changed, Bob has told me, so much the way in which that court operates today. But poor people accused of crimes brought to court in jumpsuits, issued at the jail, in handcuffs, in chains, humiliated, marginalized. Talk about treating people, as individual. These people are getting a clear message. They're not being treated as people. They're being treated as animals. They're being treated as animals. They're brought into court in chains, like slaves off a slave ship. Of course, not at trials. I realize that. When we have a trial, we get everybody dressed up, suit and tie, sweater, nice, and we have that for the jury. But every time a person's brought to court, no matter what it's for, it involves the dignity of the person who's brought to court. One of my death cases, I brought the clothes and tried to get the sheriffs to let the client change, and wouldn't do it. I went to the judge. The judge said, "Well, Mr. Bright, what difference does it make? It's me." I said, "It's not you. It's dignity. My client has a right to appear in this court with dignity." Of course, I know not enough marshals. Takes too long. It's too complicated. I mean, after all, we're sending 2.3 million people to prison. We're sending another 7 million people who are on probation or parole, and there's just not much time for each one. But we talk about reentry. That's sort of in vogue these days, to talk about reentry because we've sent so many people to prison. But I will tell you this: if people are mistreated by the courts, by the police, if they're humiliated by the courts, if they're brutalized in prison, don't worry about reentry, because you're not going to overcome those experiences with a little reentry program. It ain't going to do it, particularly because we're never going to spend enough money on a reentry program to really have a good one. Well, you have power. You have independence. I practice before judges who, if they rule in my favor, they'll be voted out of office in the next election. They're up every 4 years. You have independence. You have power. You can do something about it. This is the same approach we have, I think, with regard to the Sixth Amendment right to counsel. Are we just going to muddle through because we don't have enough money? I mean, Judge Friedman, Judge Walton had the article today in the Washington Post. Are we going to sequester the Sixth Amendment? Just recently, the federal public defender in Columbus, Ohio, said that he was laying himself off because he had been cut back so much and he didn't want to lay off the young lawyers in his office, people that moved across the country and practicing there and uprooted their families and all that. He's going to lay himself off. Federal judge in New York saying we can't try bin Laden's son because the public defenders are taking furlough days and they're not available to do it. Are we just going to muddle through? I mean, that's what the states, many states, the states I've been in, have been doing for the last 50 years. And the thing that worries me so much about the federal system is that the fact, or the people making decisions today, I urged the federal defenders years ago, don't get under the judiciary. You'll be sorry if you do. You need to be independent. But today, they're in the judicial branch, the defender services. And for some of the people that make decisions in these cases doing a good job, the fact that they've done an outstanding job, the fact that they've been models in whatever they've done in defending people and in capital cases and other cases, that's not a reason to keep funding them. Edith Jones, as the chief judge of the United States Court of Appeals for the Fifth Circuit, helped so many prosecutors by cutting back on denying district court judges would authorize experts. She'd cut it. It authorized payments to lawyers. She'd cut it. One lawyer told me he tried a 3-month death penalty case and didn't get paid 1 penny for it because she cut him off. Right now, there's a case pending in the Court of Claims from some expert accountants who were cut off by Judge Jones. I'm impressed by how great the problem is and how little we're doing about it. Eric Holder, in the anniversary of Gideon, got us all together over the Justice Department. He said we were in a state of crisis, and he announced various grants totaling, I was sitting there listening, and that sounds pretty good, but then I started adding them up, and it only came to $5 million. I mean, that wouldn't make a dent in one state, except maybe Rhode Island. DOJ is already spending about $5 million, so it comes out to a little more than $10 million for indigent defense, as compared to $1.1 billion for state law enforcement and prosecution. Last year, the Department of Justice spent $100 million on conferences. So we look at all this, and it sort of tells us where representation of poor people accused of crimes ranks in the priorities. And the money is not for boots on the ground. You know, I remember when Clinton would say, you know, we got to have 1,000 police officers or 100,000, whatever it was. And we got to have 100,000 teachers. We need 100,000 public defenders in this country. That's what we need. We want to get serious about this. But no, it's to do studies to find out, does holistic defense work? I can save so much money. Yes, it works. Look at the public defender service in Washington. Second, it's irrelevant. Most public defender services are handling 500 cases a lawyer. They don't have any time for holistic defense. They don't have time to give their clients basic representation to go see them at the jails. These problems have been studied to death. I know some of you know the Attorney General. Next time you see him, tell him this is nothing. You haven't done anything, man. You've talked a good game, but you haven't done anything. And if we're going to get out of this, it's going to take the kind of leadership. Last night I had the great privilege of giving an award to Walter Mondale, who is the Attorney General of Minnesota when Gideon was before the court and Florida was asking states to come in on Gideon's side, Florida's side. And Walter Mondale turned it around and he got 22 states that came in on Gideon's side and said, if we're going to have a system of justice, we've got to give people lawyers. I said last night, we wouldn't get that kind of response today. Today, depriving people of competent representation is an accepted prosecutorial strategy for winning cases in many places. I urge you not to take comfort in the fact that you have so much to be proud of, and you do, that you are much better than other places, that you're better than the worst by far, but to strive for a greater measure of justice here in the District of Columbia. We have not realized equal justice under law, but as Justice Brennan used to say, this is the lodestar of our aspirations. This is where we want to be as a society. This is what kind of people we want to be someday. Maybe not in my lifetime, maybe not with this Supreme Court, maybe not with this administration, but that someday people will stand equal before the law. And we'll have a society in which people do have capable lawyers that provide zealous representation and are treated with the basic human dignity to which all God's children are entitled. Thank you very much.
You know, usually I try to make a comment to sum up what's been said. I think today I just will be quiet and let it sink in because it was powerful. Thank you very much for your remarks. I have the pleasure and of informing all of you that we're running ahead of schedule. Are we still? Oh, I believe we're running ahead of schedule. And so that you will have an opportunity to again engage each other and enjoy each other before going to the afternoon seminars. But please don't be late. They're scheduled to start at 2:15, and we have an outstanding group of presenters, and I think you will find it most educational, informative, and you will enjoy it. I have one other house cleaning matter to address, and that is, again, because while I introduced all of the judges of my colleague, Chief Judge Lamberth's court, United States District Court, I didn't see this one, and he serves a special role for our courts, the chair of the Judicial Nominations Commission, U.S. District Court Judge Emmett Sullivan. Emmett, thanks for being here, sir. And with that, we are adjourned until 2:15 and the seminars. Thank you.